Ladies and gentlemen, our first speaker this morning is Professor John M. Evans from the Osgoode Hall Law School, who's going to be speaking to us on the very important area of administrative law remedies, an area that, of course, in the last several years has developed very swiftly indeed. He is preeminently qualified to speak to us on this subject because, among his other honors, he has been chosen to be the editor of DeSmith's textbook on judicial review of administrative law. Certainly was the textbook we had to have when we went to school, and still is, I'm told, the leading text. And I am told that it is a definite honor and a coveted position to be the editor of it. As well as that, he has just brought out a case book on administrative law. And somewhere in his lecture, I'm sure if you listen very carefully, he might even give us some reason or rationale for the existence of the divisional court. I would hope so. They give you a curriculum vitae, which is on file at Osgoode Hall when you're introducing the speakers. And I noticed looking down it quickly that he's really one of us, because although he was born in Great Britain, the next line says citizenship. It says United Kingdom and colonies. So John went to the London School, lectured at the London School of Economics, at Worcester College in Oxford, at the University of Chicago, and was a visiting professor and is now a professor at Osgoode Hall, as I mentioned earlier. His articles and his writings are very numerous indeed, most of them in this area. Professor Evans.
Thank you, Mr. Chairman, for those generous, if totally unwarranted remarks. Can you hear me at the back? I'm audible? Good. And that awful light shining at me. Well, I've already discovered that I've disappointed two people. I'm not the John Evans from Hamilton, but maybe the disappointment will stop there. Let me just make two preliminary points by way of explanation as to what will follow. The first is that this is very much the short lecture of a much longer paper. My time and your patience allow me to touch only upon some of the points that are developed further in that paper. That means, of course, that if I manage to whet your appetite for more, then you can read at your leisure, some months in the future, some more of what I say, and you may even be able to find some authority for some of my more outrageous propositions. On the other hand, of course, if I persuade you that this is an area of the law that doesn't deserve more than 45 minutes so early on a Saturday morning, then when the printed pages come, you can very quickly skip over those particular chapters. The second point is a little more substantial and concerns the scope of my remarks. The title to which I was to speak, Recent Developments in Remedies in Administrative Law, might have conjured up to you some of the more arcane procedural technicalities associated with the old prerogative writs, declarations, and injunctions in public law, albeit that those things now turn up in their modern guise of an application for judicial review, or even perhaps, heaven help us, some of the deeper mysteries of the Federal Court Act. But rest assured, I shall scarcely mention any of those things. Instead, what I want to speak to you about this morning is those aspects of administrative law which in the last few years have not just developed, but which indeed have been revolutionized. And I want to talk about the substantive grounds upon which a legal remedy is available in the courts to a person who considers that he has been aggrieved in some way by a decision of an administrative agency. My justification, note, not excuse, for structuring my paper in this way is that by administrative law, I understand the that the phrase encompasses all the law that relates to the administration. And that, of course, includes such questions as institutional design and composition, the relationship between different organs and different levels of government, the width and varieties of legal powers which are entrusted to them, and the sorts of procedures that administrative agencies follow. So by remedies in administrative law, what I shall deal with are legal remedies available when something in the administrative process has gone wrong. My point is not just a semantic one, again, more substantial, because this is an area where, in the last few years, all the action has been. Now, in surveying some of the radical changes that in the last few years have transformed this area of the law, I hope to develop a few fairly simple themes. The first is that the evident changes in legal doctrine and the language in which legal doctrine is expressed, and the attitudes of judges towards the proper role to be played by the courts in superintending the administration, requires lawyers to become familiar with the subject that, in many very important respects, is quite new. Secondly, the subject is both technically less forbidding than it used to be, and yet, paradoxically, more subtle and challenging, because its mastery, as it seems to me, now depends upon an ability to discern some golden threads that run through the tangled skeins, and to grasp and to be able to deploy in legal argument some basic notions about the capacities and limitations of the component parts of our system of government. The opportunities for engaging the interest of the courts in the business of government has, I think, never been greater. But it would be quite forced to describe courts' attitudes as one of being undifferentiated judicial activism. Whether a court will grant a legal remedy against a particular agency on a specified ground depends to a greater extent than ever upon the increasingly sophisticated view taken by judges about the respective institutional and procedural strengths and weaknesses of courts and other public authorities. The line that divides law from public administration and politics is constantly being redrawn. Now, it's not easy to state with confidence the factors that have contributed to the remarkable changes in the law of judicial review. However, a list compiled more by informed intuition than rigorous analysis would include, I think, the following factors: the influence of developments in other common law jurisdictions, a recognition that the more conceptual approach adopted in many early decisions produced neither certainty in the law nor decisions that were on their merits very satisfactory. One, I think, would also mention the growth of government in all our lives in recent years, and the healthy skepticism about the efficacy of the political process to remedy injustices and to ensure an adequate level of responsiveness and openness in governmental decision-making. This last tendency, I think, may well have been encouraged by the appearance in the courts in recent years of more litigants with clearly limited access to the political process. For example, prisoners, welfare claimants, and public interest groups representing consumers, and those concerned with the impact of industry and the development of private property upon the environment. I ought also to mention, in my list of factors, the remarkable bundle of reforms that were passed in this province in 1971. Although this is the 10th anniversary of the 1971 reforms, I don't intend in my remarks this morning to describe in much detail their features. I will, though, try to identify for you what seem to me to be some of the more general effects that some of those pieces of legislation have had. Take first the Judicial Review Procedure Act, the act which you remember, which amongst other things introduced a single remedy within which all the old available forms of relief could be granted. Well, what effect has that had upon subsequent developments? First, I think that what the Judicial Review Procedure Act has done has been to demystify and simplify many of the procedural aspects of the strictly remedial law, which may well have encouraged lawyers to advise an application to the courts more readily and with greater confidence than had been the case in the past. The second general effect that I think one can identify is that the elimination by that act of so many of the highly technical aspects of remedial law may well have enabled counsel and judges to pay much closer attention to the substantive law of judicial review about the grounds on which a judicial remedy may be given to a litigant, rather than to be overwhelmingly concerned with the remedial technicalities. I might also mention that the Federal Court Act has had some of the same effects, although the scores of cases that have been decided about the jurisdiction of the two divisions of the federal court and the relationship between the federal court and provincial courts testify this reform in many respects has been less successful than Ontario's. The other piece of the 1971 package that I will say just a little about is the Statutory Powers Procedure Act. What that act did was to create a uniform administrative code of procedure to be applied to a large number of administrative tribunals in the province. What it did was to extend and clarify the contents of the procedural rights to which those appearing before many administrative agencies are entitled. In addition, its requirement that those tribunals to which the Act applied must give reasons for their decisions when requested has facilitated judicial review of the substantive grounds upon which a tribunal decided a case. The last point that I'd make about the SPPA here is that the Act may also have contributed to the emergence of the judicially developed standard of fairness to be adhered to by those tribunals to which the Statutory Powers Procedure Act does not apply. This, I think, may well have come about because the SPPA contained a clear legislative endorsement of the importance of open and fair procedures in administrative decision-making. It also, I think, became clear that there was a yawning gap between the very ample procedural rights provided for by the SPPA and the complete absence of procedural rights that seemed at one time to attend those decisions which could not be characterized as judicial. What the courts have done is to fill that gap between the ample procedural rights under the SPPA on the one hand and the complete absence of procedural rights on the other. What I've done in my paper is to illustrate some of the more important of the court's responses to these influences and to explain and explore developments in the principles that apply to the award of legal remedies in administrative law. My paper draws for its illustrations upon three areas in which there's been intense judicial activity in the last few years. First of all, in the area of procedure to be applied by administrative tribunals. Secondly, over the control exercised by the courts of questions of law, fact, and jurisdiction of administrative tribunals. And thirdly, and this I'm afraid I shall not have time to speak about this morning, some of the legal implications of administrators' decisions to structure the statutory discretion with which they've been entrusted. So let me speak then of procedure first. For the administrative lawyer, trends in the case law indicating that the courts are prepared to apply a particular approach or legal principle to a wide range of statutory contexts are generally much more important than decisions in individual cases. There are, however, some important exceptions to that observation, and there can, I think, be little doubt that the decision of the Supreme Court of Canada in Nicholson against the Haldeman and Norfolk Regional Board of Commissioners of Police is such an exception. In that case, the court quashed the board's decision to dispense with the services of the applicant, a probationary constable, on the ground that he'd been given neither notice of the grounds upon which the board was minded to let him go, nor an opportunity to respond to the board's concerns. Now, the doctrinal importance of the decision in Nicholson is that the court in that case categorically abandoned the requirement that a function had to be classified as judicial or quasi-judicial before any procedural rights could be implied in the face of statutory silence. The Chief Justice, giving the majority judgment in the case, referred to analogous developments in English law. And he went on to say, "What rightly lies behind this emergence is the realization that the classification of statutory functions as judicial, quasi-judicial, or administrative is often very difficult, to say the least, indeed. And to endow some with procedural protection while denying others any at all would work injustice when the results of statutory decisions raise the same serious consequences for those adversely affected, regardless of the classification of the function in question." In those rather brief words, the Supreme Court quite clearly departed from a doctrinal path that had seemed increasingly narrow. Although, like most decisions that set the law in a new direction, the subsequent twists and turns and ultimate destination of the path are as yet far from clear. One feature, though, of the post-Nicholson law is clear enough, and it is that the distinction between judicial or quasi-judicial decisions on the one hand and purely administrative decisions on the other has not disappeared altogether. Indeed, in the Nicholson case itself, the Chief Justice expressly preserved the distinction. However, what is important is the changing function of that distinction. In many cases, the primary importance of the distinction will now be in relation to the precise extent and form of the contents of a person's procedural rights, and not, as it was in the old days, whether the person has any procedural rights at all. Many judges have said that the appropriate way to think about procedural problems in this area is to recognize that administrative agencies and the sorts of decisions that administrative agencies make range along a continuum. On the one hand, there are agencies whose composition and functions and the sorts of issues that they have to decide make them look very much like court substitutes. For those agencies which fall at the judicial end of the spectrum, we will normally expect, I think, to find that the courts will say that they must give the greatest procedural protections. And then at the other end of the spectrum are those bodies and decisions which, for one reason or another, look very unlike courts and look very unlike the sorts of decisions that courts have to decide. The function of the judicial administrative distinction, then, will be to locate along that continuum the appropriate point for fixing particular procedural standards upon the agency in question. The content of the procedures the courts may require as a legal condition precedent to the valid exercise of statutory power will depend upon a multiplicity of factors. These clearly include the importance of the interest that may be adversely affected by the decision, the impact of the decision upon those interests, the differing degrees to which the decisions may depend, on the one hand, upon individual facts and the interpretation and application of statutorily prescribed standards, or on the other hand, considerations of policies relevant to the well-being of the general public. Also highly relevant will be a range of considerations that may be drawn from the statutory and administrative setting of any given case. To attempt to divide such a complex and diverse universe into a priori – rigid categories does seem unduly formalistic. There will, though, be other contexts, apart from deciding in any given case what the precise procedural form of an agency's procedure should take. There are going to be other contexts in which courts will have to draw hard lines. Let me illustrate that by reference to the Fairness Doctrine and the Statutory Powers Procedure Act. That act, as many of you will know, introduced a comparatively elaborate procedural code which was designed to crystallize the contents of common law natural justice, and in a number of important respects, it increased the parties' procedural rights before administrative tribunals beyond those included in any common law formulation of natural justice. The Act then sets out a code. However, whether the Act applies to any given administrative agency does not depend upon the inclusion of that agency in some statutory list, but depends upon manipulating the triggering mechanism, which is to be found in Section 3. And what the Act says is that it applies to a statutory power of decision and a statutory power of decision required by or under its enabling act or otherwise by law to hold or afford to the parties to the proceedings an opportunity for a hearing before making a decision. The question that I want to address now, that is most pertinent to the law after Nicholson, is that part of the section that provides that the Act only applies to those agencies required by law to hold a hearing. In particular, does every agency fall within the Statutory Powers Procedure Act if it's exercising a statutory powers decision and is required to act fairly in a procedural sense, provided, of course, that that agency has not been expressly excluded or its functions excluded from the SPPA? Well, our courts, quite rightly, in my view, have decided that not every agency that, after Nicholson, must act fairly also has to hold a hearing in the sense indicated by the Statutory Powers Procedure Act. For example, in the case of Re Webb and the Ontario Housing Corporation, the Ontario Court of Appeal held that even though the respondent corporation was required to comply with the duty of fairness before deciding to evict a tenant, the corporation was not a tribunal to which the more formal procedures of the Statutory Powers Procedure Act applied. And more recently, the Court of Appeal in Re Western and the Cooperative Review Committee and the General Manager of OHIP held that the SPPA did not apply to proceedings culminating in a determination that the applicant had submitted an excessive claim, even though, in the circumstances, the committee was legally required to act fairly. The court regarded the statutory right to be heard on appeal after the initial determination had been made as rendering the implication of a prior hearing inappropriate. Those examples are concerned with cases where no statute requires a hearing to be held, but where, by common law, the duty to act fairly will be implied. A similar issue can also arise where a particular statute expressly requires a hearing to be held by a body which in other respects satisfies Section 3.1 of the SPPA. And our question here is, when an administrative agency is required by statute to hold a hearing, does that by itself, if the other conditions of Section 3 are satisfied, automatically attract the procedural code of the SPPA? The answer, I think, here too will be not necessarily. A recent illustration is to be found in the case of Re McGill and the City of Brantford. In that case, the applicants had alleged that a bylaw ordering the closure of a highway was invalid because the respondent municipality had already so far committed itself to the measure that its bias had disqualified it from fairly giving to the objectors the prior hearing to which the Municipal Act entitled them. However, the court concluded that the SPPA did not apply to to the municipality's decision to enact this bylaw, because, inter alia, the nature both of the body in question, an elected body discharging essentially political functions, and the nature of the decision, one based on public policy and affecting a large number of people, indicated that the hearing contemplated by the Municipal Act was more in the nature of a public forum for debate than an adjudicative hearing. I might also mention that the frequency with which these questions are going to trouble the courts is limited by the express terms of the SPPA itself, because many administrative agencies which will be required to act fairly, although they are not conceptually judicial, are excluded in one way or another by the very terms of the SPPA. In particular, a body must, you'll remember, be exercising a statutory power of decision before its decisions fall to be governed by the procedure of the SPPA. That will mean, for example, that a body whose decisions are not legally dispositive of a person's rights will not fall within Section 3 of the SPPA. A recent illustration is to be found in the Court of Appeal's decision in the case of Abel against the Advisory Review Board, a body which has the function of recommending to the Lieutenant Governor whether an inmate has recovered and ought to be released. The board's decisions, of course, are not dispositive, although they are a crucial stage in the administrative procedure. The court held that the board must act fairly, even though it was not required to comply with the Statutory Powers Procedure Act, because it was simply investigating and recommending and not legally disposing of people's rights. In short, then, the Statutory Powers Procedure Act can be expected to apply to those hearings required by statute or the common law for which the trial-type procedural code contained in the Act seems appropriate. This awkwardness, almost a tautology, arises from the Act's failure to designate specifically those bodies and decisions to which it applies. It's also fair to say, I think, that the legislature was overtaken by history, in the sense that it attempted to clarify the law by reducing to statutory language the flexible concept of natural justice at about the same time that the courts were once again beginning to explicitly recognize the very different procedural forms that natural justice or fairness is capable of taking. So the question, am I entitled to a hearing, can no longer be answered, if indeed it ever could, unless a second question is also asked. What sort of a hearing do you want? I'll say just a little about fairness and the Federal Court Act, because there has been a parallel development between fairness and the Statutory Powers Procedure Act on the one hand, and fairness and certiorari and the scope of Section 28 of the Federal Court Act on the other. You'll recall that once it is clear that the activities of an administrative agency are reviewable in the federal court, the second step in the search for the proper forum in which to seek a legal remedy is to determine whether the decision being challenged falls within the supervisory jurisdiction of the trial division or of the appellate division. This depends upon the interpretation of the now notorious Section 28 of the Federal Court Act, almost every word of which has been the subject of the most wasteful litigation. The conundrum which had puzzled many was this: the remedy provided by Section 28 to review and set aside decisions or orders of federal tribunals on the statutory specified grounds did not apply to administrative decisions, note the double negative, not required by law to be made on a judicial or quasi-judicial basis. On the other hand, certiorari, a remedy frequently associated by the courts with the review of judicial powers, was available in the trial division. Now, since decisions required by law to be made on judicial basis were exclusively reviewable under Section 28 in the Federal Court of Appeal, what scope was then left for the issue of certiorari by the trial division. Well, after many trials and tribulations, the answer returned to the puzzle by the Supreme Court of Canada turned out to be a rather sensible one. And you'll find it in the recent decision of Martineau against the Matsqui Institution Disciplinary Board, number 2. We're waiting for number 3 still. And the answer is along these lines. Not all decisions required to be made after complying with the duty of fairness are reviewable under Section 28, but only those decisions to which natural justice, in its more clearly trial-like form, applies. Decisions whose characteristics place them towards the administrative end of the spectrum, but which nevertheless required to be made after the individual has been afforded procedural fairness, are reviewable in the trial division. Certiorari, it's been held, may lie to a body that is required to act fairly, even though its functions are only conceptually administrative in nature. In this and in other decisions, our courts have been commendably quick to adjust the law about the scope of the common law remedies to the expanded grounds of judicial review. The last aspect of the decision in Nicholson that merits consideration is the way that Nicholson has tended to shift the emphasis of the courts from answering the threshold question of whether the applicant's entitled to a hearing at all to the more specific one of whether the applicant on particular facts before a particular decision maker was denied a fair hearing because he was not afforded a particular procedural right. Although several of the provisions of the SPPA leave a reviewing court room to tailor the procedure to fit the exigencies of individual cases, the more flexible common law duty of fairness, which will have to be applied in a much more widely varied range of administrative and statutory contexts, will enable the courts to particularize procedures to a far greater extent than ever before. Of course, as we all know, if flexibility is one side of the coin, then uncertainty and confusing variety are the unwelcome obverse. One of the criticisms made about the adoption of this rather vague duty to act fairly is that it is enabling the court to consider the procedural propriety of a very wide range of administrative bodies. Bodies that are so radically different from those with which courts are familiar that courts simply lack the institutional competence to lay down procedural codes of conduct which accommodate the need for effective government with the interests of those subject to a particular regulatory regime. Perhaps the best answer to that criticism is to be found in some of the more recent decisions that have been emanating from the courts. These decisions make it clear that under the rubric of the duty to act fairly, courts are not prepared to act as super procedural code makers. The primary responsibility for designing rules of procedure remains still with the agencies themselves. Despite the court's insistence upon fairness, their role remains strictly supervisory. It's no more than to prod the agency to think about the problem before it in procedural terms and to ensure that certain minimum standards of procedural decency are observed. Indeed, notice that in Nicholson itself, the Chief Justice left it to the board to decide whether to invite written or oral representations from the applicant. And in Abel's case, what so upset the court was that the Board of Review had obviously adopted a general rule that in no circumstances would it reveal to applicants the details of their medical records. All the signs indicate, I think, in the terms of the judgment in Abel, that the court would have been very reluctant to hold that fairness to the individual required disclosure if the board had actually addressed itself to the facts of the particular case and had decided that to disclose the specific information requested to the particular applicant would be undesirable. These cases, and there are others, suggest that the duty to act fairly still leaves a substantial area of discretion to the agency over important matters of detail, and that if the agency has applied itself to the exercise of its discretion to a particular case, then the courts will be reluctant to intervene, unless satisfied that the agency's decision was clearly unreasonable or had caused some serious injustice to the applicant. The second area that I can now only touch upon very briefly, or we may be glad to know, is the area of substantive review. And there are two cases which, if you've not already come across them, are sure to impinge upon your consciousness sooner or later if your practice is at all in the area of administrative law. The two cases that I'll say just something about are the recent decision of the Supreme Court of Canada in Cupey against the New Brunswick Liquor Corporation, and the even more recent decision of the Ontario Court of Appeal in re Keeprite Workers Independent Union and Keeprite Products Limited. In the first case, in Cupey, the Supreme Court was faced with an issue that had come before it on countless other occasions, and it was this: in what circumstances may an individual who is dissatisfied with the decision of an administrative tribunal seek a remedy in the courts when the tribunal's enabling statute provides that it may decide any necessary question of law and fact, that its decisions are final, and may not be reviewed in any court, whether by way of prohibition, certiorari, or any other remedy. Previous cases had produced a most unsatisfactory situation. The courts had never told us, in clear terms, how to distinguish a decision on a question of law by the agency that caused it to exceed its jurisdiction. Jurisdictional error had been defined in terms broad enough to encompass any error of law at all. Indeed, Lord Denning in the English Court of Appeal recently was very pleased to announce that that indeed was exactly the position, and that no tribunal had jurisdiction to make a mistake of law. Admirers of the Master of the Rolls, le vieux terrible of the English legal system, will be heartened to learn that his lordship has been no more troubled by reproof from his judicial betters on this question than he has been on so many others. So there were the technically unsatisfactory features of the old law. There was also a substantive criticism that went along with them, and that is that the courts did seem to be saying that they could review for excessive jurisdiction whenever the agency had decided a question of law in a way with which the reviewing court disagreed. The argument made by these critics was that the court's approach ignored the clear legislative intention that such questions should normally be left with the tribunals. Their experience and specialist understanding of the area under their regulation should have persuaded courts to adopt a deferential attitude towards agency attempts to fashion from the statutory language the legal tools necessary to do their job effectively. Listen to what Mr. Justice Dixon had to say in the Cupey case, in words which show that the majority of the Supreme Court of Canada, at least, had very much taken the critics' strictures to heart. Mr. Justice Dixon said that the rationale for the protection of a Labour Board's decisions within jurisdiction is straightforward and compelling. The Labour Board is a specialised tribunal which administered a comprehensive statute regulating labour relations. In the administration of that regime, a board is called upon not only to find facts and decide questions of law, but also to exercise its understanding of the body of jurisprudence that is developed around the collective bargaining system as understood in Canada, and its labour relations sense acquired from accumulated experience in the area. After making these observations, noting the inherent ambiguity of the statutory section in question, the court concluded that the proper question for a reviewing court was to ask whether the board's interpretation of the statute was so patently unreasonable that its construction cannot be rationally supported by the relevant legislation and demands intervention. In other words, the court is saying that at least where there is a privative clause, the standard of review to be adopted on the interpretation by the board of its enabling statute is one of unreasonableness or patent unreasonableness and not simply wrongness. The implications of the Cupid decision are, I think, quite clearly going to be far-reaching. In a decision of the Ontario Divisional Court that came out very soon after Cupid was decided, Mr. Justice Reed, in a most thoughtful judgment, was eager to embrace the reasoning and to elaborate the reasoning in Cupid. The effect of Cupid, though, I think is not confined simply to the old questions of whether a question of law decided wrongly by the agency has deprived it of jurisdiction. There is also clear evidence that the very considerations that prompted judicial caution in Cupid may be almost as compelling in circumstances where there is a right of appeal on questions of law from an administrative agency, or where there is an error of law apparent on the face of the agency's record. And this point was made very clearly by the Divisional Court in the recent case of Shulman and the College of Physicians and Surgeons of Ontario, where the appellant had argued that the college's discipline committee's decision that he'd been guilty of professional conduct in publishing an article about another doctor's patient was wrong in law. The appellant contended that the relevant regulation, when properly interpreted, only forbade a doctor from divulging information about his own patients. The court concluded that the college's interpretation was, in fact, the better one. But nonetheless, the court relied upon the Cupid decision for formulating the proper attitude of for a reviewing court, even when exercising an appellate jurisdiction on questions of law. Mr. Justice Montgomery said, "I'm of the view that we should look carefully at how the tribunal interpreted the statute, and if judicially reasonable, look favorably upon their interpretation." In other words, what the court seems to be saying is that the considerations of expeditious decision-making and the advantage that the legislature sees in entrusting decision-making at the first instance to a specialist tribunal should be retained, even where there is an appeal on questions of law and the interpretation of the tribunal's enabling legislation is at stake. Well, if Cupid marks a step back by the courts and marks a toning down of the rather harsh light that the court has in the past shone upon questions of law decided by administrative tribunals, the Keepright decision is very important for the converse, because what Keepright does is to shed some light into the darker corners of administrative findings of fact. Before the Keepright decision, it was very difficult to persuade a court to intervene on the ground that an administrative tribunal had got its facts wrong. Unless the fact could be characterized as jurisdictional, very difficult to do, or unless the tribunal had in its record set out all the evidence upon which it purported to act, and it was clear from that record that there was no evidence supporting a given finding of fact, the court said that they could not review. Moreover, in the Privy Council's decision in Nat Bell, it had appeared to be laid down quite categorically that a tribunal did not lose its jurisdiction by making a finding of fact based upon no evidence. Well, if the decision of the Ontario Court of Appeal in Keepright sticks, that is now old hat. In Keepright, what had happened was that an application for judicial review had been made to quash a labour arbitration award on the ground, inter alia, that the arbitrator had made findings of fact which were not supported by any evidence before him. To this end, the applicants wished to introduce affidavit evidence to establish that nothing was said at the hearing to justify the arbitrator's finding that the grievor had admitted that he'd thrown coffee in another employee's face. an incident for which he had been dismissed by his employer. Having admitted the affidavit, the court concluded there was overall ample evidence before the arbitrator to support his general conclusion that the employer's version of the fact was substantially correct, and that the grievor's dismissal for fighting was not in breach of the collective agreement. Although the court accepted the applicant's contention that there was no evidence for the arbitrator's specific finding of an admission by the grievor, the decision was nonetheless allowed to stand because of the strength of the other evidence. It would, I think, clearly be a mistake to regard the failure of the applicants to obtain the remedy sought in Keep Right as reducing that decision to a mere squall in a coffee cup. The court identified two bases upon which to assert its authority to review the award for no evidence, even though the absence of evidence was not apparent on the face of the tribunal's record. First, it said, as a broad proposition, that a complete absence of evidence for a material finding of fact constitutes jurisdictional error. Well, a number of the authorities relied upon for that proposition by the Court of Appeal turn out to be pretty equivocal when they're examined more closely. What of Nat Bell, you may ask? Well, the authority of that case was rather brusquely brushed aside, like some wayward and unwelcome elderly relative at a family gathering, as a decision which, in the words of Mr. Justice Morden, has had a checkered career. More importantly, though, for us, I think, is the alternative basis upon which the court concluded that it had authority to review findings of fact for no evidence, even though the absence of evidence was not apparent on the face of the record. And the court found its authority in Section 2, subsection 3 of the JRPA, the Judicial Review Procedure Act. And that section does say that where the findings of fact of a tribunal made in the exercise of a statutory power of decision are required by any statute or law to be based exclusively on evidence admissible before it and on facts of which it may take notice, and there is no such evidence, and there are no such facts to support findings of fact by the tribunal in making a decision in the exercise of such power, the court may set aside the decision on an application for judicial review. It's easier when you read it. Well, what the Court of Appeal said of that section was that it clearly applied to this arbitrator's decision. The arbitrator was, conceded on all sides, exercising a statutory powered decision. It was a statutory arbitration. Moreover, said the Court of Appeal, the arbitrator's function was, quote, obviously judicial, unquote. And therefore, since it was obviously judicial, it fell within the other terms of Section 2.3, namely that the decision was required by any statute or law to be based exclusively on evidence that is admissible before it. So what Mr. Justice Morden and the Ontario Court of Appeal seem to be saying is that any tribunal which is required to comply with the rules of natural justice, does that include fairness, is now reviewable for no evidence, even though the lack of evidence is not apparent on the face of the record. Now you might think from the plain meaning of the words that there's something to be said for that decision. There is no reference to errors appearing on the face of the record in Section 2.3. You can contrast 2.3 with Section 2.2, which says that the court may review the exercise of statutory powered decision when an error of law appears on the face of the record. 2.2 refers to record, 2.3 does not. You might also say that to keep the requirement the error appear on the face of the record in 2.3 would be to maintain an anachronism about the scope of the common law remedy of certiorari. Unfortunately, though, when the legal history of Section 2.3 is examined, it seems to me, at least, to be quite clear that the Court of Appeal misunderstood the scope of Section 2.3. And the crucial words are those words that the decision be required by any statute or law to be based exclusively on evidence that is admissible before it. I have to be very short in telling you what the legislative history is. The place to start is with the McClure Commission's report, the report that inspired much of the 1971 legislation in Ontario. What McClure suggested was that what they called the expanded scope of judicial review for lack of evidence should apply to some administrative tribunals. They call those administrative tribunals judicial. And what they said was that it should be the function of the Statutory Powers Rules Committee to designate those tribunals whose decisions should be reviewable for lack of evidence. So they envisaged two classes of tribunals: those to which the SPPA generally applied, and then other tribunals who were required to decide on the basis of a record, by which they meant decide on the basis of evidence admitted before them, and who were under a duty to keep a record of the proceedings. In fact, when one looks at other pieces of the jigsaw, it is quite clear that the legislation has indeed singled out certain tribunals as being subjected to the 2-3 standard of review. If you look, for example, at Section 30 of the SPPA, there you'll find that the Act provides that tribunals governed by the Act who have a rule-making power may exercise that rule-making power to do a number of things. One is to require that they decide exclusively on the basis of evidence admissible before them. Another is that they be required to keep a record of their proceedings. If you look at the Civil Rights Statute Law Amendment Act in 1971, there you'll find a number of tribunals who were specifically designated as being required to decide exclusively on the basis of evidence admissible before them, and who are also invariably required to keep a record of their proceedings. It's my contention, then, that Section 2.3 only applies to those tribunals that have been identified by statute or by rules made under statute as required to decide on the basis of evidence before them that fall under Section 2.3. And the reason is clear. The reason is, as the McClure Commission pointed out, that it is highly undesirable as a general practice to allow the divisional court, any reviewing court for that matter, in a summary proceeding to have to decide disputed questions of fact by hunting through what was said, by having affidavits produced as to what happened in the proceedings by those who were there. In other words, then, 2.3 only applies to those tribunals who are required to make a record, so that there will never, or there should never, be any occasion to have to introduce affidavit evidence about the proceedings before the tribunal. Well, Keypride has not, as it turns out, gone any further than that. In one sense, of course, there seems to be something to be said for the decision at a rather general level, because what it seems to be doing, when you take it with CUPE, is to be introducing a general standard of review. Namely, it's saying that decisions of administrative agencies are always reviewable for unreasonableness, whether the unreasonableness be in the findings of fact or in the questions of law. Well, attractive as that may be, it seems to me, and you can read it if you like, that the dangers inherent in that approach outweigh the advantages. Let me sum up, albeit rather late in the day, as follows. The case law that I discuss in the paper, and some of which I've been able to mention today, undoubtedly marks a rapidly growing maturity in the ward of legal remedies in Canadian administrative law. New doctrinal framework has been needed because it had become increasingly clear that the old provided a totally inadequate structure within which to consider important questions about the role of the courts and legal remedies in administrative law. Of course, the new building is far from complete, because the plans upon which it's based, ideas about the proper relationship between courts and other governmental organs, are still little more than rough sketches. But if current developments in the law are any guide for the future, the circumstance in which legal remedies and administrative law are going to be granted by the courts will be influenced less by the repetition of empty legal shibboleths than by an intelligent blend of established legal principles elucidated by constant application in widely differing contexts, and a grasp of the underlying assumptions and characteristics of our system of government and its component parts. Participation in these formative stages of legal growth is likely to prove both challenging and exciting.